Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address the critical issues facing businesses and consumers today. It's legal information, practical solution, and straight talk about a wide variety of topics from family and finance to Social Security and workers' compensation. Most recently, we've been talking about Social Security and Social Security disability, and at the end of every show, we always invite our viewers to email in or call in, but email in to dbazaar@abcglawfirm.com if you have any follow-up questions. And gladly, happily, once again, we have a question for our lawyers to address, Lenny Cordeiro and Jackie Grasso. Welcome again, and are you ready for the question?
We're ready.
Okay, as we were talking about Social Security disability, here's the question. One writes in, if Social Security disability means that we are impaired enough medically, psychologically, however, impaired enough not to be able to work, does that mean that we cannot work at all, or is there just a limit to the amount that we can earn, $900 a month or something? What are the terms or parameters?
Ironically, with Social Security, it's kind of a double-edged sword. When you apply for Social Security, before you've actually been approved in the process, you cannot work. I've had situations where people are either working part-time or working reduced hours or working limited duty because of their impairments, and the Social Security Administration won't even take their application. So prior to a person being approved for Social Security, I would strongly suggest that you cannot work or earn any income. However, once you've been approved and once you are actually receiving a monthly benefit, Social Security does allow you to attempt to perform what they call trial work periods. So you can actually attempt work and you can actually earn up to that $800–900 a month that we were talking about for a certain period of time. Usually it's over a 9-month period, over a 3-year stretch, where you can earn up to that income and not have your Social Security benefits reduced. Once that 3-year period, though, is completed and you've worked for more than the 9-month period of time, then you are presumptively presumed to have gone back to work. So the answer to the question is, before you've been approved, you cannot work and earn any income. After you've been approved, you're allowed to attempt to try to return to work and do what you can. And if for some reason your return to work attempt is unsuccessful, you do not have to reapply all over again. Social Security will reinstate your benefits and continue to pay you just as if you had never worked.
And because this is federal, you said it doesn't matter whether it's Rhode Island or Massachusetts, correct?
That's correct. If it's a federal law, it applies uniformly across the United States, whether you're in Rhode Island or Hawaii or Alaska. It's all the same law because it's federal.
Anything else that we need to discuss about that?
What about the work restrictions? Isn't there, in other words, can they go back to the same type of work? So if they're in carpentry work, can they go back in limited hours, or can they just go back to a desk job like in workers' compensation?
Actually pretty good. That's actually a good question as well. Usually, Social Security will not look at necessarily what type of work you're doing. They're really looking at whether or not you meet the impairments for purposes of being disabled. Once you meet those impairments, whether you go back and try your regular job for a limited period of time, whether you try a different job, limited duty, limited hours, so long as you remain disabled for purposes of their impairment guidelines, you can go back and try any type of work you want. But generally speaking, if you have an impairment that qualifies you for benefits under Social Security, you rarely see a person go back to his regular or her regular job, just simply because that's, for the most part, that's what ended up taking them out of the workforce in the first place.
Makes sense.
Yeah.
Okay.
Yeah.
Well, onward. So while housing foreclosures are abound and people are still losing their homes, what about the economic situation or crisis that, and how does it impact different relationships with those who are dealing with commercial or residential real estate? So this week we thought it would be a good idea to talk about landlords and tenants. You're a landlord and you want to evict somebody, the tenant. The tenant has problems with the landlord and doesn't want to pay. Everyone has rights. This is why we have laws that are meant to protect everyone. What is the story? What are the issues revolving around eviction and Rhode Island and southeastern Massachusetts?
Well, I'll start with Rhode Island. Jackie is a little more versed in the Massachusetts system than I am, so I'll speak to what I know. As far as Rhode Island, some of the issues that you'd want to take a look at, if you're the tenant, and you fall behind on your rent, which I think is pretty common right now given what the economic situation is, the landlord has a right to send you what they call a 5-day demand letter, which is once you fall 15 days in arrears with your rent, you receive a letter from the landlord. It usually goes out regular mail. And if, in fact, you receive that letter, you have 5 days to pay your rent to current. If you do not pay your rent to current within 5 days of receipt of that letter, on the 6th day, the landlord can commence an action for eviction for non-payment of rent. And usually in Rhode Island, after the summons is issued, you're in court within 9 days, so it's a pretty quick process. And non-payment of rent is probably one of the few situations where, regardless of how much of a hardship the person is undergoing, or, I've had situations where I've seen, mothers holding their children, their babies in court saying, I couldn't pay my rent. If, in fact, they are behind on rent and they do not make the payment within the 5 days, the landlord is entitled not only to possession of the premises, but also to the back due rent. The judge will have some flexibility in giving the tenant some time to either find some other accommodations or make some other arrangements. But ultimately, non-payment of rent is a pretty cut and dry situation. If you don't pay and you don't make good within that 5-day period, the landlord does have a right to get possession of the apartment or the premises and evict you.
I thought that, or I've heard that it takes an awful lot to actually evict someone. That's not what my understanding was at all. Apparently you're saying it's quite easy to do that.
No, I didn't say that. What I said was that
once you're in the court system, it's pretty rapid once you go through the court system.
Right, and not only that, but it is, let's put it this way, judges are very sympathetic to tenants. And if you're not talking a rent situation, it is very difficult to evict someone, because then it becomes a situation where it's a he said, she said type of situation, and it becomes one person's word against somebody else's. Also, even though that part of the process is very quick, what a lot of people don't realize, especially landlords, is that you usually start out in the district court in Rhode Island. So if there is an order for eviction that is entered against you, the tenant or the party that is usually on the losing end has the right to appeal to the Superior Court. If the tenant is the losing party and they appeal to Superior Court, the landlord cannot really take any further action to evict them. So the process of actually going from district to Superior Court could take somewhere between 30 to 45 to 60 days, depending on how backlogged the Superior Court is. The caveat, though, is, or the little catch, is that in order for the tenant to have his case heard at the Superior Court, he has to continue to pay rent during the pendency of the appeal. If the tenant does not pay the rent, then the landlord automatically has a right to ask the Superior Court judge to dismiss the appeal. And then at that point, the landlord can take steps to further evict the tenant. So even though the process seems to be pretty clear-cut for the landlord on rent, the tenant actually has some remedies available to him or her to prolong the process. And believe it or not, that happens quite a bit. It's kind of frustrating, I guess, for a landlord if you're in a situation where you want to get someone out fairly quickly and turn the apartment over to rent to someone else, but those remedies are available to the tenant.
Jackie, is there any difference between Rhode Island and Mass?
Yeah, it's somewhat different. I'm going to talk about non-payment of rent first, because then the other situation is other than non-payment of rent and why a tenant refuses to pay rent. So that's an entirely different subject.
Too,
so that's where it becomes difficult to get someone out of an apartment very quickly. In Massachusetts, if you are delinquent on your rent, just like in Rhode Island you would send a 5-day demand for the rent, in Massachusetts you would send what's called a 14-day notice to quit. Similar to Rhode Island, same substance in terms of what you're seeking. You're seeking the back rent. It has to be brought current within this particular period of time. If it's not brought current by the 14th day, then what you can do is you can take action in the housing court. So for instance, in Bristol County we have a housing court in Fall River. You would commence what's called a summary process